Thank you, everybody, for being here for our last segment. We have a judges panel. It's Perspectives on Patent Litigation, where we stand now. Joining me on the stage to co-moderate this conversation is Scott McEwen from Wolf Greenfield. Scott's the co-chair for this program, so I thought he may have some questions that he might want to ask the judges as well. Now, these three individuals need no introduction. I'll give them a very brief introduction. Anyway, I've always said that when your introduction can be one sentence and it encapsulates everything, that means you know you've made it in the industry. And we have three federal circuit judges here with us today, two former chief judges, and obviously Judge Newman, who is to the audience's left. The Honorable Pauline Newman is currently on the federal circuit. She's been on the federal circuit for a number of years. We were just talking about that. She has been a friend to all of us in the patent community, and a mentor and a leader and an example, really, of what you should be for the community. And we appreciate you being here, Your Honor. Next to Judge Newman is Chief Judge Michel. Chief Judge Michel famously left the bench about a decade ago because he wanted to be able to tell people what he really thought about the patent system and what needed fixing, and he does that. Maybe we'll get into a little bit of those extracurricular activities that he's involved with. Every piece of legislation that is moving and not moving, some alike. Thank you, Your Honor, for being here. And last but certainly not least is Chief Judge Randall Rader, who also was a federal circuit chief judge. And I won't say who appointed you all, because that'll date all of you, and it'll also date me to some extent because I know all of them who appointed you. But Judge Rader's been on the bench for a number of years, and now he's in private practice. He does arbitration, he does mediation, and he does consulting, as does Judge Michel as well. And I think we're in for a robust conversation about the patent system. And maybe what I'll do is I'll ask Judge Newman to go. Well, actually, before I do that, Scott, do you have any thoughts on this panel before we kick off?
No, I'm just excited to get into it.
Good. So maybe what we'll do is we'll point of privilege, Your Honor, Judge Newman, we'll let you go first. And whatever it is you want to tell the audience, please go right ahead and tell us.
All right, I'll do that. So good afternoon, everyone. I'm delighted to be here on this important and interesting watchdog panel. IP litigation is becoming more and more complicated, and it's becoming more and more interested, I would think. Most important, it's extremely important to the nation, to all nations, that advances in technology be accompanied by full and fair dispute resolution and by full and fair law, justice. This is where the judges come in. The target of litigation is the judge. The judge will decide who wins and who loses. That's what judges do. These elaborate techniques that you'll be talking about at this meeting have only one purpose, and that is to persuade the judge to your point of view. This is a heavy responsibility for an advocate. Aristotle said the advocate must start with human character, with human emotions, accompanied by logical reasoning. But the judges must decide, based on reflection, calling on all of our experience, as well as the past experience shown in precedent, and all to serve the exercise of judgment. Judgment is what judges are supposed to do. As judges, our focus is on the substantive law. There are occasional issues of due process and other procedures, but these issues, even when they warrant judicial attention, are unlikely to affect the march of human existence, whereas the advance of technology can have a major impact on humanity. Now, this is where the Federal Circuit comes in. This court has the last word in most disputes concerning patents. Its position, its view of policy, its reliability and wisdom can directly affect the nation's progress into the technological future. Even where the Supreme Court has entered the arena, it befalls the Federal Circuit to apply any new principles that are stated by the Supreme Court to the extraordinary variety of technologies and issues in the present and in the future, the unforeseeable, the unforeseen future that precedent applies to. This is especially important in deciding close questions, for a judicial decision on closely balanced facts can lead to broad statements and sweeping precedent. In my view, this has led to some of today's flawed Federal Circuit rulings. Most conspicuously, the Circuit's errors, I believe, have been with respect to Section 101 and 112, but they're not unique. Today's new technologies are dramatic, and they promise for the future. Their promise is powerful. Although today's economic conditions don't match the conditions of the drastic recession that prevailed when the Federal Circuit was formed, I suggest that the need for review has again arisen. At the time the Federal Circuit was spawned, the United States had the lowest rate of growth of technology-based industry of any industrial nation. We had the highest percentage of obsolete plants. We had the lowest percentage of capital investment and the lowest growth in productivity and savings of any industrial nation. There was extensive study, most effectively by a 2-year study called the Domestic Policy Review of Industrial Innovation, called by President Jimmy Carter. Under that review, and as its result, the nation made several changes in the governmental framework for industrial innovation. This included changes in the tax law, in antitrust understanding, and related to the patent system. I was a participant in that study. We foresaw a new industrial age based on technology that had matured after World War II. We stressed the importance of patent principles, and we stressed the need for a reliable, predictable patent right. Patent-related legislative actions included the Bayh-Dole Act for government-sponsored research, the Hatch-Waxman Act for pharmaceutical products, and the first change in judicial structure since the inception of the circuit courts. At that time, the regional circuit courts had marked differences of policy and precedent concerning patents. Industry blamed this on a flawed understanding of how science and research worked. The Federal Circuit was formed to remedy this defect, to produce uniform and reliable national law based on a solid understanding of how industrial innovation works through investment in R&D and commercial prospects. It was expected that this new court would continue the understanding and wisdom of its predecessor courts, the Court of Customs and Patent Appeals and the Court of Claims. And it did so. There was a dramatic resurgence of technology-based industry based on confidence in the laws that were enacted to support technology and to support technology-based industry. There was confidence in the court that was created to administer these new laws. The Federal Circuit even got credit for pulling the nation out of recession and moving the nation towards the world leadership in technological innovation that was, in fact, achieved. Much was said about our nation's international leadership as a model of judicial integrity, of justice under law, again praising the Federal Circuit. For the first 2 decades of its existence, the court's decisions in all of the areas assigned to it produced stability, predictability, and wisdom. New judicial areas were added to the court, including appeals from the newly formed Veterans Court and appeals from the vaccine activities of the Court of Federal Claims. And meanwhile, technology was advancing apace, and patent litigation was encountering new issues as digital technology developed. Study was again initiated, and after some 10 years of discussion and debate and legislative hearings, there was enacted the America Invents Act. The purpose of the AIA was to restore a reliable patent system through a new administrative process with appeals to the Federal Circuit, including a system of estoppel in the trial courts for patents that went through this new administrative procedure. There has been, as we will discuss, a marked downturn in patent infringement suits since then. In 2012, there were 6,497 patent cases filed in the district courts. And 10 years later, in 2022, there were 3,630. And the number of appeals to the Federal Circuit has dropped commensurately. This reduced activity does not change the responsibility of the Federal Circuit. This court sits at the pinnacle of patent jurisprudence to state the law correctly, wisely, and justly. All the tribunals that are making decisions about patents are applying the law announced by the Federal Circuit. If anything, the burdens on the court have increased, for a vast number of adjudicators are now attempting to apply the law as we have announced it. In my view, the Federal Circuit has erred in some areas of law. I think probably the most important, but there are several. The most important is the subject matter eligibility aspects of Section 101. When an inventor or investor is told by his friendly patent attorney of the uncertainty of judicial support of his invention, if the invention is successful and is marketed and is copied, that is a factor in the decision of whether to proceed at all with the innovation. The cost of patent litigation is a factor in all investment decisions, and in the present climate of judicial unpredictability, it can be dispositive. Several of you have told me interesting facts of decisions made. The loser is not only the loss of commerce and productivity, the loser is also the public that is deprived of the technological advance. That's what the Federal Circuit was supposed to remedy in the interest of the nation's national and international strength and leadership. If the Federal Circuit is failing in this responsibility, it is of national concern. Technology is a stage of rapid and fascinating development. The new questions reaching the court are not always easy. When I thought the court had slipped in its decisions or reasoning, I said so. My criticisms were apparently not well received, for, as you know, my colleagues have responded by suspending me from hearing cases in defiance of the Constitution. Our nation's strength is its commitment to justice. Litigants must have confidence that the judges will be governed by the principles of reason, morals, ethics, and fairness that are the foundations of justice. When a court abandons these values, we should all be concerned. So I leave you with this concern, for the Federal Circuit may be doing irreparable damage to the judicial reputation for objectivity and justice, a great strength of the United States culture worldwide. This injury is not only to me, but to the nation. So I leave you with this disturbing thought.
Great, thank you, Your Honor. I appreciate that. Now, I don't want to pigeonhole your reaction or response in any way. Judge Michel, we'll start with you. Judge Rader, I'm going to ask you the same question. Is there anything that Judge Newman has said that you'd like to react to?
Well, first I'd like to comment, Gene, that it is such a pleasure once again to appear on a panel with Judge Newman and Chief Judge Rader. We sat together often in times past, and to reassemble today is a total joy. Secondly, I would like to say that Judge Newman's remarks, very carefully articulated and structured, bring us back to the mission of the Federal Circuit, why it was created, when it was fulfilling the mission, and now maybe not so much, maybe now largely failing the mission. And she points out the consequences of that to the prosperity of the country, the technological leadership, but also to competitiveness. And I'd like to spend just a moment on competitiveness. In today's world, competition is highly globalized in almost all industries. And therefore, it matters a lot whether US-based companies are disadvantaged compared to rival countries overseas. And so the disparities have huge impact. So for example, injunctions in the United States are now rare. They remain, however, routine all over Europe and in major jurisdictions in Asia, and that even includes China, as well as Japan and Korea and Taiwan and others. So if we lose sight of the global competition, we are going to destroy the future of this country. The next perspective I'd like to suggest is that while patent lawyers and patent litigators are so absorbed in their important work, and it is important and constructive, it's easy to lose sight of the fact that the main object of the patent system is not so much lawyers, whether they prosecute patents or litigate cases or have other roles. It really is a matter of protections that can incentivize investment. It comes down mostly to money. The inventive talent of scientific and engineering trained people in the United States is immense. We have a huge phalanx of top research universities all over this country, and companies that are packed with talented people. But in the end, the critical decisions are not made by inventors. They're made by people who manage money, CEOs in established companies, venture capitalists in the case of startups and newer companies. And so you have to watch where the money goes if you want to understand what's happening and whether it's promoting the welfare of the nation or not. And it's very clear from growing indicators that now venture capital money going into real technology as opposed to, for example, entertainment is flagging. And that's true in the corporate world and in the VC world, both. And where the money goes, the future is going to go. And not only is the investment level now reduced, there's more VC money than ever by a lot, but the portion going into real science is diminishing. And even worse, it used to be that American venture capital money and other funds were spent mostly here in the 80% range. Now it's down to 50%, and a lot of the money is going overseas, a huge portion of it to commercial rivals, such as countries and their companies in Europe, but also in Asia, and once again, including China. So we're putting ourselves at a big disadvantage. Final point is that the Federal Circuit was created to bring uniformity, clarity, consistency, and I would also suggest strength to the patent system. And it did that, Judge Newman says, for 2 decades. I might say for 3, but that's a quibble. It's not doing it so much anymore, and that's a tragedy for the country. You know, the patent system is almost entirely a statutory system. There are little bits of equity here and there, but it's basically statutory law. And when the courts get it wrong, because precedent governs future adjudications, it's difficult to change those precedents. Federal Circuit, for example, would have to go in bank to overrule some of its disparate decisions or clarify which ones were authoritative and to make corrections where necessary. In the last decade, it's almost never gone in bank in a fundamental patent case, which is another wasted opportunity, or I would almost say dereliction of duty. And even at the panel level, the Federal Circuit could be doing much better than it's doing. For example, the Supreme Court cases in eligibility that Judge Newman highlighted were highly hedged in the language by the Supreme Court itself in those 4 cases. But as they've been applied by the Federal Circuit, they've been applied in a distinctly hostile fashion toward patent strength and predictability. And that's unfortunate, but now it's locked in precedent. So the district judges have no choice. The patent authorities, PTAB and examiners also have no choice. They have to follow the law. And therefore, I've concluded that the only rescue of the patent system is going to have to come primarily from the U.S. Congress to clarify what it intended in the America Invents Act, what Section 112 was supposed to do and not do, and the same with the other key sections of the patent statute. So I'm very involved, along with former directors Kapos and Yanku and others, in trying to promote progress of legislation pending now, and particularly in the Senate, that's taken the lead. There's still a very important role for the courts. I don't mean to suggest otherwise, but I think we need intervention at this point from the Congress, as well as for the Federal Circuit to do better, and the Supreme Court to clarify what it was really trying to accomplish, particularly in the eligibility cases, but also in other cases like KSR on obviousness doctrine and eBay on the availability of injunctions. So everybody has heavy lifting to do, and in my view, we need to get going on it.
Great, thank you, Your Honor. And Judge Rader, open floor, what do you want to say? What do you want to react to? Do you want to take us in a new direction? It's up to you.
Just, you know, this is the only panel I've been on in many years where I'm the junior member. I don't know if that's flattering or not. Let me just echo and put exclamation points behind everything you've just heard from 2 of the most eminent jurists in the history of the Federal Circuit, but even beyond that, in the history of the entire commercial judicial system. And I'm just going to tell 2 quick remembrances. I remember, along the themes of what you said, Judge Newman, Polly, those early circuit conferences with Howard Markey and Helen Neese and Glenn Archer. We would have, maybe I'm exaggerating, but 2,000 or 3,000 people in the audiences. And there was such an enthusiasm for what the Federal Circuit was doing. I can remember the repeated speeches on how the Federal Circuit has rescued patent law and reinvigorated commercial investment, and everything that you said, Paulie and Paul. I don't hear that kind of joy. I remember when you were our chief judge, Paul, we commemorated the 25th anniversary of this circuit. And it was a big event and such enthusiasm and happiness over what had been accomplished. And I feel now that we need umbrellas. We're under a cloud of rain rather than a happy, sunny atmosphere. That's one reflection. Another is picking up on one of your themes, Judge Michel, the Chief Judge Michel. I was asked to advise a corporation on where to file suit on an important portfolio that they had. And the attorney introducing me said, we're all anxious to know, will it be Delaware? Will it be the Eastern District of Texas? Maybe even Illinois. And I said, there's a clear answer here. Dusseldorf and Shenzhen. And of course, I'm making the point in a story fashion that you made, Paul, that the jurisprudence in those areas allow for an early injunction and will give the leverage to do what litigation is supposed to do anyway, and that's facilitate a settlement. Now, by the way, you asked earlier, Gene, in the last panel, with such a turmoil in patent jurisprudence, why are companies still reflecting that over 50% of their patent portfolio and value is in the U.S.? Well, that's essential too, because you want to settle using U.S. damages law, which is still the best in the world. So yes, we sue in Dusseldorf and Shenzhen, shut off the supply coming from China, and capture the European market with that injunction, but then we'll settle using U.S. law because that gives us the best value. At least it did. You're right, Judge Newman, that the value of our intellectual property assets, they're property assets, Gene, I know that's been questioned in jurisprudence, but our property assets will inevitably begin to lose value if they're not fully enforced. And not just in Shenzhen and Dusseldorf. I am so proud to be with these two giants in the commercial law area, and I hope that we've heard what they've said, that there is work to be done to recapture the spirit we used to have at those old Federal Circuit conferences that I don't think is still there. Thanks, Gene.
Great, thank you, Your Honor. Scott, any thoughts or questions of the panel?
I guess I'm just curious, Judge Michel, you'd mentioned the Federal Circuit's treatment of the 101 guidance of the Supreme Court as, somewhat tying the hands of the district court. And we talked earlier this afternoon that there's only been one en banc hearing, relatively recently, and what's caused that shift in I don't know if it's a shift in attitude or a reluctance maybe to be activist in decision making. What is it that sort of changed?
Well, in the early decades of the court, there was a very strong unifying factor where the court tried to speak with one voice, speak clearly, be consistent from year to year and case to case. Where it was necessary to go in bank, the court was willing to go in bank, went in bank regularly. There was a careful attempt to listen to colleagues and come out with a unified opinion.
We even went on banc sua sponte a couple times, didn't we, Paul?
Yeah, we did. We did. And so there was a whole ethic. It was the DNA of the court to be clear, to be predictable, to be consistent, and to not engage in policy making on a personal level. And nowadays it seems to me that some judges seem to have the attitude, I want to reshape the patent law to my own personal view. And I'm on a panel with two other people. If I can get one of them to agree to me, I can reshape the law. And then the court will never go in bank, so my decision will stick, and it will govern the whole country. That's a very evil circumstance, I would say, very destructive. So I don't like that. And I'd like to say a word, it's not maybe exactly in answer to your question, but it picks up on something Judge Rader emphasized in terms of settlement. For every dispute or potential dispute involving patents that is settled in a courtroom, there are many, many, many more settled in a boardroom. And we've destroyed that system. Now nothing much gets settled voluntarily or in the boardroom or as a matter of practicality. Now it's go to the PTAB, slug it out, multiple attacks on the patent, big delays everywhere, cases stayed. You know the whole story, the whole litany. If you destroy the efficiency of voluntary settlements, you've destroyed the whole system. There will never be enough judges to promptly and fairly adjudicate every patent case. So most patent cases are going to have to be settled somehow or other as opposed to being resolved by judges. And you can't do that if you have chaos. And I think what we now have, it rises to the level of chaos, but we have it in our power to change that. And we really need to change it because we're in a period where if we don't make fundamental changes, U.S. prosperity, scientific leadership, global economic power, and even national security are going to continue to sink as they already are sinking. So we don't have any choice. We have to shape this system up, and we need to do it as fast as possible.
Yeah, Gene, you've kind of asked us to reflect on the state of litigation. There is a particularly disturbing litigation trend, and that is we spend a lot of time fighting over venue and standing, procedural issues, instead of getting to the question, is there infringement? And that, besides adding to the cost, expense, and delay of the situation, has deterred the use of courts, the decline that Paulie referred to in the filings. I think it's enhanced a little bit the arbitration systems, but that's disturbing that we all know the Federal Circuit was created, among other things, to resolve venue problems, but they're worse today than they were then.
They are. And the one thing that, when I was a younger attorney, I didn't really appreciate this, although I saw it in action. And in reflection, with all the years that I've lived, and now I see what was really going on then, I always thought it was unusual why would the judge ask us if there's any opportunity to settle this case? You know, because they're not going to be involved in this settlement. And I had one occasion, it was a pretrial hearing right before the trial, and the partner that was going to try the case wasn't there. It was a 4-hour drive from our office. In New Hampshire, there's some of the courts that are kind of hard to get to, you know, so I would get that assignment, go to the, and the judge asked, he said, look, I'm not going to ask you to answer this question out loud, but I want each of you to write this down and pass me a note. What's the number that you can settle at right now? And he said, all I'll do, if you're both agreeable to this, is I will tell you whether it's worthwhile for you to try and aggressively mediate this case over the weekend. You know, because we're going to select the jury on Monday. And we wrote it down, passed them the note, gave them, we had a number, and presumably the other side did not have a number. You know, he looked at it, he said, okay, we're selecting the jury at 9 a.m. on Monday morning. You know, but the judges were engaged in trying to get to a resolution. And I clerked for another judge, and he said, look, if I make a decision, nobody's going to be happy. He said, if they come to a resolution, they're going to be happy about some stuff, not happy about other stuff. But presumably, they're going to know which is most important to them. If I make a decision, I might give you what's least important to you and you what's least important to you, but to me, that's a decent deal. I don't see judges today, in the patent system at least, trying to get to the outside settlement. And I think that that is a huge problem. And we get these decisions on decisions on decisions, and there's no business sense in this. Am I wrong? I mean, did you guys see other things? I know you know a lot of district court judges, not asking you for any confidences, but what's the dynamic that goes on?
Business sense is a very good phrase that you just used, Gene, because for judges to do well with the patent system, they have to have a reasonable sense of business decision-making, not just lawyers, but business executives. Judge Newman brought to the court, to its great benefit, enormous experience in a major corporation where she was the chief patent counsel for a long time. And that informed all of us about the realities of people who are making fateful decisions. And that seems to be fading badly, this business sense, practical business sense. And I think that, frankly, there are too few judges who have any business insight or any sense of basic economics. And yet, at least in commercial litigation, particularly patent litigation, it's all about economics. That's where all the leverage and the benefit and the risk and the harm all comes from. So if judges aren't savvy about business sense and basic economics, they can't do a very good job. So a lot of this has to do with the selection of judges being added to the Federal Circuit and other courts, and we clearly need more people like Judge Newman and fewer people whose sense of patent law is only from books.
So, Judge Newman, I'm sensitive to the fact that you're still on the court, and presuming that the Federal Circuit is not going to just usurp the Constitution, you will be back on the court at some point in time. But they'll save those issues for another day. But I don't want to ask you anything that will put you in a position where you might think that you can't comment. But what I would like to just give you the floor for a moment, if you'd like to respond to anything that Judges Michel or Judge Rader has said so far.
Well, I can respond in that both Judge Michel and Judge Rader have, with their experience on the court and with their life experience, have identified what the issues are, the areas of concern for not just the court, for the nation. And with this audience, I hope inspiring us to think about where we are, to consider the largest picture of powerful national and international consequence, and think about what we can do, again, to stir things up. For some 40, 45 years ago, before the Federal Circuit was anything that anyone had even contemplated, there was at last a powerful movement, generally led by industry, by the private sector, but with a few other scholars of jurisprudence, of the economy, of commerce, to think that this is a situation, this default in the nation's technological leadership is something that can be remedied, that must be remedied, and by golly, let's figure out how to do it. And again, we are nationally and internationally, as one looks at what's going on in the various wars all around the world of every country, of the technological advances, of the bases on which these wars are now being fought, that we are in a powerful, competitive situation internationally, in addition to the areas that come before the courts. In the United States, since we also get the appeals, as you know, of claims against the United States in government contracts, those people generally have the sense not to take their disputes to the courts, but to work them out. At the same time, there are issues throughout. They all not only are technology-based issues, but they are issues on the advancement of technology, fostering what's called the spirit of innovation that our future as a nation depends on our resolving. This is a much bigger picture than the Federal Circuit, but it is a national picture in which you, all of you, in your areas of expertise and attention, have the opportunity to understand, and I'd like to say the obligation to pursue.
You know, Gene, we're on the topic of litigation and the perspectives of it in our current situation. I'm worried about the problem of separating validity from infringement. Now, validity is not a freestanding doctrine to those of us who teach patent law. It is a defense to the main cause of action of infringement. And yet when you separate the defense from the infringement, which is the basis for it, you get a distortion in the system. The biggest distortion is that you can get a different claim construction for validity than you get for infringement. And indeed, for many years, that was institutionalized with the broadest reasonable interpretation for validity and a more specific interpretation for infringement. And I'm not sure that disconnect between two doctrines that should be inseparable has been remedied. And I know you're working on legislation to deal with this problem. Paul, do you think we're going to make any progress with that?
Eventually, I think the Congress will pass some of these bills. The bills mainly deal with, first, eligibility, secondly, with injunctions, and third, with the Patent Trial and Appeal Board procedures. I think eventually they'll pass. The question in my mind is, will it be soon enough to reverse the decline that's already underway? And everybody who cares about the patent system and about the progress of science and useful arts, as the Constitution puts it, has a role to play. Many of you here file amicus briefs in important cases. I think that's a very important role. Another important role is to try to motivate your clients, the companies, to become active. You know, there are about 30 congressional staffers on the relevant subcommittees in the House and the Senate who stand at the crossroads right now on these pieces of legislation. these young staffers don't understand patent law at all, and there's no reason that they should, really. They're smart, they're highly educated, they're young, they're inexperienced, they're under huge time pressures, and so forth. But they need to be educated, and every competent patent lawyer can participate in that in a very constructive way. And then, of course, the members themselves need to be better educated as well. But the starting point, the entry gate, is the staffer. So amicus briefs, going to Capitol Hill and educating staffers and members, writing articles, motivating clients to get involved, all these things can help. And all of these things are within the power of the men and women in this room here today and all of your peers elsewhere.
Go ahead, Your Honor.
Well, it occurs to me to encourage all of us to think creatively. For example, just inspired by Paul's comments, we're waiting to see what the Unified Patent Court in Europe does with the issues of validity. There is quite a strong movement there, I understand, to adopt the French theory of validity, which essentially does not include a concept of obviousness, but only of what we would call anticipation. And then you have a patent that is freed of the major areas of attack in the United States and in some European countries, a powerful stability of the intellectual property right, and as to where that will take, to try and learn from the experience of all nations. This is in many ways a time of change and flux, and we can learn a good deal. And we can not only from the European Patent Court, but also from the way the law is developing in Japan and in China. In China, a delegation of judges came to see us many years ago, and we talked to them. I told them very plainly what I thought was wrong, could be improved with the Federal Circuit, and they adopted what I said to form the Chinese court, and with the qualifications of judges and a lot of other things. We can learn a lot by watching how that's working in China. And so this is a very interesting time to be in this business. This isn't old news. This is in many ways a new ball game, and at a time of such dramatic promise in the new technologies and the digital world that it would be a dramatic mistake not to apply the most advanced and creative thinking that we can come up with.
You know, Gene, it's ironic. If you think of a graph, the strength and clarity and predictability of American patent law has been going down steadily since I would trace it to eBay, so 2006. In rival countries, the strength and predictability of patent law has been going steadily up. And so now we've crossed places. So now China, Germany, all of Europe, Japan, many other jurisdictions have better patent systems, better patent offices, better litigation, better outcomes, better incentives for investment than we now do. How crazy is this?
I think it's the grass is greener on the other side, right? You know, because if you recall across the board back 10 to 20 years ago, the elite were telling us we need to be more like Europe. We need to be more like Europe. We need to be more like Europe. At the same time, that's about when Europe started trying to become, in a lot of respects, more like the United States. Where's the call anymore to be more like Europe? I mean, I'm all in favor at the moment to be more like Europe. And I only say that partially tongue in cheek. Obviously, I love America, and I'm a proud American, and I can't see myself living. I'll visit other places, but I can't wait to get home, you know. But I would like the America that we were, that is in a lot of ways like Europe is today, to be our future. Now, one thing I wanted like to do is, Scott, get you to introduce into this conversation. I know you have a great way of saying it, and I always hate how you say it because it's contradicting, or not contradicting, but it's countering my argument. But you always point out that, these companies that are American companies, and they do hire and employ American people to do business in America. And so I've kind of started to try and temper myself. Like in the last, I don't know whether it was a shock to you, probably not, we talk a lot, to hear me say that, I can understand the argument that MPs maybe shouldn't get an injunction. There's an argument that can be made there, based on the law and the facts. But can you introduce that line of thinking? Let's get the judges to react to that. Because I think it's interesting talking about the Federal Circuit as a commercial court, because it is. But not a lot of people do talk about it in those contexts.
Yeah, well, and I think the counter argument would be, well, yes, eBay went away in 2006, but patent law has changed a lot since then, and we have, we'll just call them profiteers, and it's not to say that the innovations that they're pursuing are less valuable than others, but there's more of an industry, a litigation industry. And, we have large companies in this country that employ tens of thousands of engineers, and they spend untold millions on research. And if things were to stay exactly as they are today, they would be facing an injunction twice a week. And how is that sustainable? So yes, if it's a competitor versus competitor, dispute, the way that you might think of it, in the 1970s, maybe, Chrysler is battling Ford, and yeah, in that context, you can kind of see that, the injunction makes a lot of sense there. When you apply it to today, when there's just so many hundreds of suits against, frankly, large U.S. companies that are driving the economy, how do we thread the needle of not, pretty much putting those companies out of business?
Yeah, and I'll just
usually evaluate litigation on the basis of the characteristics of the parties. You look at the legal issues. My quickest professorial response to you is that if that patent is of value, it doesn't matter who is asserting it. We are defending the value of that invention, and frankly, inventors generally are not very good litigators. So it actually serves the value of the property to transfer it to someone who can realize its value. In the real property corollary, we like the idea of transferring property from one person to another so that it gets its most efficient use. Same thing here. We don't judge the property on the basis of who's asserting it. Whether it's a university who's not going to be making products, but are the most vigorous, inventive entities we have, whether it's someone like that or it's a corporation who itself has its selfish motives for putting forward its property. From our perspective, we ought to step back and say, as long as that property is getting its most efficient value, the system is being well served.
So can I ask you, because I fundamentally tend more towards that view philosophically, but I am not unsympathetic to the extortion that goes on in some levels.
Extortion will only happen if there's a mistake made, Gene. If you get the damages equation right, you won't have anything other than the property getting the value that it deserves.
So let me just push back on that a little bit, because I think certainly that's true.
I've taught this for 35 years. You're going to have trouble with me.
I don't think I will, because I don't think fundamentally we're in different places, right? Because I think I know the three of you pretty well. And I think if the cases go to maturity and there is a difference of opinion regardless of who the patent owner is, and you put all the evidence on the table, whether dealing with validity and damages and all that sort of thing, the right answer is achieved more often than it's not. Even still in the U.S. system, I will say that, right? But I think where things get awry, and where I refer to it as the extortion, is the patent owner who, whether they're making anything or not making anything, and they sue and they're willing to settle for 10 grand. You know, if it was only a 10 grand case, the economics are such that nobody in their right mind should have ever brought in that patent litigation to begin with. You were bringing that to get out before the settlement conference, and which is what they do a lot of times, because they don't want the district court judge to have any inkling that they're willing to settle for 10 grand, because if that comes up during the scheduling conference, I said settlement conference, I mean it's scheduling, but that comes up before the scheduling conference, the district court judge looks at that case a lot differently. So how do we deal with
argument you're
that?
making is that there are slumlords who do own real property. But you know, the best way to solve that problem is to return the property to its most efficient use, which happens when the slumlords are replaced by the market system, which will put that property to its best use. So trust the system, which in this case is patent law. And of course, I have to put an asterisk here because Polly and Paul have seen so beautifully that at times the system is not working the way it should. But if we see patent law performing according to what I call an international standard, then that property will be put to its most efficient use. It will gravitate away from the slumlords to the efficient users of that property. But the key is the system has to work to make that operate.
Gene,
So I may have
just-
said, let me just say this quickly. I may have given you the quote of the conference a little too early when you said hamburger to filet mignon, because slumlords describes perfectly the problem that I see. Judge Michel?
Well, the system has means to deal with frivolous lawsuits, bogus lawsuits, extortionate lawsuits, and they ought to be utilized. And it's probably the case that some district judges are not utilizing their power to punish and deter, including with fines, frivolous litigation. They have the power to do it. They ought to do it. They do it sometimes. They probably should be doing it more often. But the mechanism to deter and punish bad conduct is in place. So to trash the whole system in order to get at this cohort of bad actors is not necessary and not wise and not constructive. There's a better way to handle it.
I wish I'd said that.
Well, I wrote an article about that, exactly that many years ago, saying that I think district court judges, when I was litigating, the district court judge knew that they were the most important person, most powerful person, certainly in the courtroom, probably in the entire county. You know, a district court judge has got a lot of power, and today I don't think they use it nearly enough. Judge Newman, did I see your hand?
I was reminded, I was recently at a conference at Fordham, and there are a number of judges there from various countries. And so I asked some of them, I said, do you have the same problem with what we call patent trolls that we do? And they said universally, no, we have a very simple answer. Loser pays.
Yeah,
Loser pays
I've started
the
seeing
That
the
ends
merits in that, because it does. I mean, it really forces you, to use a poker analogy, you're going all in, you know, and maybe we should have a loser pay with an asterisk where a judge can look at the party's arguments and say, no, that was based on your position, reasonable what you did and reasonable what you argued, and maybe it's a wash then. But ordinarily, I think we would go a long way to have the loser pay.
It has to be flexible. You know, if it's a presumption that can be rebutted, it can be fairly applied. But if it's a rigid rule, it's going to wreak havoc.
Yeah, litigation funding would pretty much end overnight, I think, if that were the case.
Yeah. So I'll have to go back and think about that as well. But we're about a minute away from giving all these fine people 1 hour of CLE. The articles, and one of our newest columnist, Judge Rader, has written most of the articles that make up the CLE materials. Judge Michel has written one of them on his 35-year perspective in patent law. So those are linked on the panel page. But in the last minute, rapid fire, what do you, and I'd like you to comment on this too if you want. Maybe we could start with you so that we give the judges the final word. What is your takeaway message from this conversation?
I would agree with Judge Michel. I think we've gotten to the point where we do need, and further to Judge Newman's point, some kind of Bayh-Dole, Hatch-Waxman type package of serious reforms to work in parallel with the Federal Circuit to undo some of the damage. 101, being first and foremost. There's not going to be a one-size-fits-all solution. Who is suing? Maybe. Where that property ends up when you're balancing injunctions and equities, maybe that should matter when you're looking at potential damage to a large U.S. company. And I don't know that we'll get there given the polarization of U.S. politics, but, we have to try.
Gene, I'll make a prediction.
Go ahead.
If the legislation starts to move, short of passage, short of enactment, if it starts to move, I predict the courts will get on the stick and fix these problems on their own. That happened before,
We've seen that.
And it'll happen again.
Yeah, well, great. Thank you, Judge Michel. Judge Rader, your takeaway message.
I still have hope that the Supreme Court will correct itself, starting with eBay, fundamentally with eligibility. They were so carefully hedging everything they said. They have to have doubts, and those doubts can be corrected. And finally, I certainly hope that the Federal Circuit will take seriously the message that Paulie gave them earlier today and seriously strengthen patent law instead of undermining.
Great, thank you, Your Honor. Judge Newman, the final word goes to you.
I've learned from listening to my colleagues, ex-colleagues, and to the extent that you have pulled us all together here with a chance to talk and understand and explore and possibly even take action for the future. This is important. This is what it's all about. The future of the nation is in our hands, in the hands of the practitioners, in the hands of you who know better than anyone what the issues are, the considerations, the balances, the trade-offs, the compromises, and to figure out where the national interest lies, and then make it happen.
Great. Thank you very much, Your Honors. That was wonderful. Thank you, Scott, for participating. And today is now adjourned, and I hope you will join me for a cocktail and some